Good day, Crime Talk aficionados. We have a great show for you today. First, DNA solves a cold case in Hawaii. Prosecutors are coming at Karen Read's experts really hard. What did I tell you? Mistrials never benefit the defense. Should we be concerned about the prosecutor's actions in the Karen Crumbley case? Flying your drone can get you criminal charges if you fly it into an airplane. A man steals the identity of another man and convinces the police that the victim of the crime is actually the fraudster. And remember that guy in France, Dominique Pelicot, had other men do terrible things to his wife while she was drugged? Well, guess what? He's under investigation for another case. This guy, his boots got him identified and ultimately arrested. Another reason to avoid dating apps. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Before we get started, though, I want to let you know about something. Last week, I guess almost 2 weeks ago, we did an interview with Joshua Ritter over there at True Crime Daily. Anyway, they're going to put up our interview. Hopefully I don't sound like a complete idiot of me tonight at 6 p.m. Mountain Time. And we will, since it's a premiere, going to try to join in on that as well. Hopefully enjoy it. You know, talking to other people is always good. He seems like a good guy. So go over to Joshua Ritter's show today. Check it out. And who knows? Maybe you'll learn something more about me, and you'll say, my gosh, now I know why I trust this guy so much, because he is just one of us. He was no silver spoon in his mouth kind of guy coming up. Not at all. So let's open the record for February 3rd of 2025. Can you believe February is here, ladies and gentlemen? All right, first on the docket, a cold case is solved in Hawaii. That's right, police used advances in DNA technology to arrest a 66-year-old resident of Utah at his nursing home for a murder that took place in Hawaii in the 70s. Now, the guy who is the suspect, and we'll give him the presumption of innocence, is a guy by the name of Gideon Castro. He appeared via WebEx video on Friday from a hospital bed in a medical wing at a Utah jail. Now, Castro told the judge that he wanted to hire his own attorney. Therefore, they set the next appearance for this coming Wednesday for the initial appearance to advise him of the charges. So how did all this get started? Well, back on March 21st, 1977, shortly after 7:30 a.m., police in Honolulu found Momoharo Don lying on her back, partially clothed, an orange cloth wrapped tightly around her neck. Needless to say, she had been sexually assaulted and strangled, according to the police reports. Well, the morning before Momoharo was killed, she got a call from an unknown male and told her mother she was going to a nearby shopping center with friends. That was the last time that her mother saw her daughter alive. Now, police released sketches of a person of interest and a possible vehicle described by a witness as a 1974-1975 Pontiac Le Mans. A witness reported seeing the car when he and his girlfriend drove through campus the night before Momoharo died. If I didn't mention it before, the killing took place at the school where Momoharo attended. Now, the witnesses saw the man and the car on the grass near the school's English building. Now, police were unable to identify a suspect, and obviously the case ultimately grew old. But back in 2019, cold case detectives asked for a forensic biology unit to examine several items of evidence from the scene, including Momoharo's underwear. They were able to develop a DNA profile back in 2020. Then, in 2023, police received information about a potential suspect, two brothers who had been interviewed back originally in 1977. Several days after Momoharo was killed, detectives interviewed Castro, who graduated from this high school in 1976. He said he met Momoharo at a school dance that year and saw her at a carnival on campus back in February of 1977. Police interviewed his brother, who also met Momoharo at the same dance. Then, in November of 2023, Honolulu police went to Chicago where the brother was living. They surreptitiously obtained DNA from one of the brother's adult children. Lab findings excluded the brother as a suspect, but a DNA sample from Castro's adult son and later from Castro himself proved that he could not be excluded and was potentially the responsible party. Well, he was arrested last week at a nursing home where he lived in Salt Lake City. The charge, suspicion of second-degree murder. We'll continue to follow this case simply because, well, frankly, it's interesting. I always find cold cases that do get solved obviously have a DNA component, and it's also interesting that, well, the police had a pretty good idea, or at least came in contact with the suspects early on, but they couldn't prove the case. Next on the docket, Karen Reed is going to have a tough time at her second trial, ladies and gentlemen. Prosecutors are coming out swinging at the experts. And they did so again in a hearing that was held last Friday. The prosecutors called the work forensically and scientifically unsound, as they are arguing to have the experts from Karen Reed's first murder trial excluded from her second murder trial. Now, Karen Reed's trial is scheduled to begin on April 1st, and the retrial will feature many of the same witnesses as the first trial, but the special prosecutor, Hank Brennan, wants a key defense witness, Richard Green, to be excluded. Now, Green's testimony at the first trial centered around Google searches done on witnesses Jennifer McCabe's phone. McCabe, whose Reed's defense had pointed to as being at the center of the alleged conspiracy, used her phone to search, quote, how long TIDIE in CIKD and HOS long to die in the cold. But the question of when the searches were performed is central to the defense case. Now, while the prosecution says the searches were done at Reed's request after 6:30 a.m. when O'Keefe's body, the boyfriend, was found, the defense say the searches were performed at 2:27 a.m. before Reed even knew that her boyfriend was missing. Well, at the hearing on Friday, Brennan asked Judge Beverly Cannon to schedule a Daubert hearing to challenge the admission of the evidence. Now, Daubert hearing establishes whether a proposed expert witnesses meets the necessary qualifications to admit the testimony into court. The prosecutors argue that Green's testimony includes baseless claims and was an attempt just to create confusion and to disparage and to make claims that are factually untrue. Specifically, they say, Brennan took issue with Green's opinion that at 2:27 the search was deleted either by deliberate user inaction or manual post-imaging manipulation of the data by some unknown individual. It's a suggestion that a witness with no other evidence was involved in a conspiracy to murder somebody. That's the inference he wants the jury to hear, the prosecutor says, and that's an extraordinary harsh claim when you don't have any facts to back it up. Now, Reed's newest attorney, Robert Alessi, argued that there is no need for a further hearing because Green is qualified and no objections were raised to his opinions or methodology at the first trial. And Reed's attorney further argued that there's no need for a secondary hearing because the disagreements concerning Green's opinion are not his methodology. Well, Judge Cannon said in a written order several hours after the hearing that she is comfortable making a decision about the motion without an additional hearing. Now, the defense has separately indicated that it plans to file a motion to dismiss the case, but it's waiting for additional discovery that they received to do so. Now, Judge Cannon told them that they must file a motion by February 11th, and the motion will be addressed by February 18th. Now, I would anticipate what the judge will do is say, I'm going to allow this witness to testify, and if you believe it's false, then you bring in your own witnesses, and you are subjecting the expert for Miss Reed to cross-examination, the greatest truth-seeking tool ever created. In this particular case, I think it's interesting that this prosecutor, who's really now a defense attorney who came out of retirement of being a prosecutor, is going so aggressively at Karen Reed's case this particular time. But as we have mentioned, this is not a good thing for Karen Reed when her case resulted in a mistrial. The defense had their one shot. They couldn't do it. They didn't get there of not guilty. And now the prosecution is going back through and they're trying to fix everything that they needed to do in the first trial that either A, they didn't really anticipate, or two, they really didn't understand. And so now it gives them time to fix it. That's why I'm a firm believer. If you're going to go to trial in a multi-co-defendant case, you go first. You don't want to miss trial because you're going to lose second time around. It is much more difficult, ladies and gentlemen. Next, Jennifer Crumbley case. That's right. Ethan Crumbley, obviously, the prosecutions say that he needed his mother's guidance, some understanding from her, some recognition that maybe things weren't right in his life. And the prosecution said, well, she gave him a gun instead. Now, Jennifer Crumbley and her husband obviously gave Ethan access to a firearm. And whether it was early Christmas present or for their kid that had some mental health issues depends on, who you're talking to, I guess. Needless to say, a jury found her guilty of 4 counts of involuntary manslaughter last February. And needless to say, I'm sure she would love to take back her actions, but she cannot. But throughout this ordeal, obviously people found her to be completely dislikable, thought that she was not a good mother and not very sympathetic as a defendant either. So, can we blame the prosecutors, though, whose pretrial's actions prompted potential concerns from the judge last Friday as it relates to Ms. Crumbley's appeal? Possibly. That's right, we can. As I've said before, I think the Jennifer Crumbley conviction is horrible. Now, don't get me wrong. She is not going to get the Mother of the Year award. Both she and her husband failed as parents. I truly believe that. But I don't think being a bad parent is necessarily a crime, okay? They could have said, here's your new car as an early Christmas present, and he could have driven it through the crowded parking lot and killed even more people. Would we have said they were going to charge her then? No, I think it had to do with the instrumentality, in this particular case, obviously, a firearm. But the concerning part here is the conduct of the prosecutors. And this is when the prosecutors go after this win at all cost mentality. Remember, a prosecutor is supposed to serve justice, right? Justice is the result, not to win. And if they don't think they can prove the case, then they shouldn't go forward with the case, particularly when it's a unique, novel idea. Obviously, the first parent ever charged for conduct of a child in a school shooting. Needless to say, what we found out through the course of defense motions and the hearing was that the prosecutors offered proffer agreements to the Oxford High School counselor, a guy by the name of Sean Hopkins, and the former dean of students, Nicholas Ejak, E-J-A-K, who met with the 3 Crumbleys just hours before Ethan went on his little shooting rampage. But the agreement guaranteed that the statements made by Hopkins and Ejak in their proffer meetings would not be used against them. Basically means they would have no case against them. But as it came out last week, the attorney for Jennifer Crumbley said, guess what? The prosecution never told the defense about those particular agreements. Clearly, the judge was not pleased. Because guess what? It's probably information that should have been turned over. I'd say absolutely should have been turned over. And I would give the Crumbleys a new trial because of this prosecutorial misconduct. You may not like it, but you can't hold something like that back. And that's why routinely, we get admonished by judges. Why do you file these motions? Because, Judge, I'm covering my butt. I want all agreements made by witnesses, co-conspirators, anybody else, any offers of leniency whatsoever. And guess what, ladies and gentlemen? Why didn't they go after the school counselor, the dean of students? They're the ones that actually spend more time with Ethan Crumbley during the day than the parents do. You would think that they should have filed charges against them if they're going forward on this unique legal concept. But the prosecution picked the people that they didn't like. There were ones that, we could try to hold accountable, mom and dad. Anyway, the prosecutors are like, well, we didn't really have to turn that over. And the judge is, I think, not happy. And I think that the bigger issue is going to be she's going to have to grant a new trial. I really do believe that. But then there came another little issue. There's apparently a family connection between the chief prosecutor, a guy by the name of David Williams, and the executive producer of the Hulu documentary, whose crew practically lived in the prosecutor's office during the Crumbley trials, which were obviously subject to a gag order. We know that before the Crumbley and her husband, James, became first parents in the United States held responsible for gunning down classmates, Williams did particularly gracious favor to his wife's cousin by marriage. That's right. If that seems a little like a family link, I don't know what is. I think that's a problem. Now, when the documentary came out, Sins of the Parents, the Crumbley trials, and it aired only 9 days after the Crumbleys were sentenced to 10 to 15 years in prison, Williams' concern was the timing, not its content. Now, in an email, the producers tracked down by some press wrote, during the filming, we were under the impression that the documentary would drop months after the verdicts and sentencing, not days. We were stunned to have the trailer drop on Good Morning America and in Times Square less than 72 hours after the sentencing. Well, needless to say, some prosecutors even think that that's a little weird for that to take place, particularly if the other side doesn't know about it. And then on top of that, that's right, the prosecutors spent over $100,000 for a PR campaign to basically disparage the Crumbleys in the press, not only locally, but nationally as well. So the prosecutors were engaging in a coordinated media attack against the defendants. Yeah, that's kind of icky and gross too, don't you think? So, as the defense was arguing, what the prosecution case lacks is in the law. And basically, everybody knew it. So the prosecutors attempted to make up for their lack of legal standing as it relates to a good, solid case, not their ability to bring the case, in the court of public opinion. That's right. They tried to sway everybody else that these people were absolutely terrible to go forward with this. And I dare say for political reasons, because it's the politically expedient thing to do. Somebody's got to be charged. We must do it now. We don't want cooler heads to prevail. No, we want somebody charged now because it'll make us all feel better. Anyway, the Crumbleys were an easy target, were they not? They were. Anyway, we'll have to wait and see what the judge rules. I hope she gives the Crumbleys a new trial, ladies and gentlemen. For the lack of disclosure by the prosecutors as it relates to basically immunity agreements and the fact that there was a coordinated campaign against the Crumbleys when there's gag orders in place, hiring somebody else to do what the prosecutor couldn't do themselves. And then on top of that, the documentary team literally living with the prosecutors when it's not disclosed what was taking place. It stinks, ladies and gentlemen. You may not like it, but even if you think the people are terrible, you got to give them a fair trial. Next on the docket, don't fly your drone because it could hit an airplane and you could get charged criminally. A Los Angeles County man admitted he illegally flew a drone over the Palisades fire that crashed into and damaged a Super Scooper firefighting aircraft. Peter Aikman agreed to plead guilty to one count of unsafe operation of an unmanned aircraft, and the United States Attorney's Office in LA made that announcement last week. The misdemeanor offense carries a sentence of up to 1 year in federal prison. And according to his plea agreement, on January 9th, while the massive firestorm was sweeping through the Pacific Palisades neighborhood, Aikman launched a drone from the roof of a parking structure in nearby Santa Monica to observe the destruction. He flew the drone about 1.5 miles towards the fire, and after he lost sight of it, the drone collided with a Super Scooper attempting to fight the blaze. The crash caused an approximate 3 by 6 inch hole in the left wing of the aircraft, and it had to be taken out of service for those repairs to take place. At the time of the collision, the FAA issued temporary flight restrictions that prohibited drone operations near the wildfires that erupted earlier in January. Anyway, it goes on in the plea agreement, says that the defendant recklessly flew an aircraft into space where first responders were risking their lives in an attempt to protect the lives and property. And this damage caused to the Super Scooper is a stark reminder that flying drones during times of emergency poses an extreme threat to personnel trying to help people. Anyway, the Culver City resident agreed to pay full restitution to the government of Quebec, who owns the plane. And the drone that caused the damage, well, guess what? Plane damage was $65,000, and the drone is pieces. As part of his plea deal, he has also agreed to complete 150 hours of community service to support the 2025 Southern California relief effort. In a statement, the defense attorney said that Mr. Aikman is deeply sorry and cooperating with the government in an effort to make amends, and obviously mitigating factors that will come to light during the court proceedings, including Mr. Aikman's reliance on the DJI drones geofencing safeguard feature and the failure of that feature. Now, as you may recall, the fires erupted on January 7th in the Pacific Palisades, a pretty nice area there at the foothills of the Santa Monica Mountains, overlooking the ocean. And pretty nice area of town, which has obviously been devastated. The firestorms, fanned by extreme winds and fueled by parched vegetation in the canyons, destroyed most of the neighborhoods. And there's estimated destruction of $250 billion in economic damage, making it one of the most costly natural disasters in U.S. history. Mr. Aikman got off easy, and I would be cooperating too, for a misdemeanor when you could have been looking at going to prison. And thank God the plane didn't crash and kill even more people on the ground. You got off easy, Mr. Aikman. Next on the docket, this guy stole a man's ID and got the victim arrested. Listen to this story. So Matthew David Kierans pretended to be somebody he wasn't. He ultimately obtained a birth certificate. He got credit cards. He even worked as a high-level hospital administrator under this fake name. He even tricked police into thinking his victim was the one who stole his identity, forcing the victim into jail and a mental hospital because law enforcement deemed the man to be crazy. How long did this go on? 3 decades. Now, Kieran's multi-decade scheme is now over, and a judge in the Northern District of Iowa sentenced Kierans to 12 years in prison after he pled guilty to 1 count each of aggravated identity theft and false information to a national credit union administration. The scheme started in the late 1980s when he and William Woods worked at a hot dog cart in Albuquerque, New Mexico. Prosecutors say that Kieran stole Woods' identity and proceeded to use it in every aspect of life for the next 30 years. He got false documents, including a Kentucky birth certificate with Woods' name on it. Over the years, he applied for and obtained loans using the victim's information, netting some $250,000. In 2013, he became a high-level administrator working in an Iowa City hospital by submitting a fake I-9 form, social security number, date of birth, and other identification documents in Woods' name while working remotely from his home in Wisconsin. Now, as Kierans was enjoying life under this false name, the then homeless Woods in August of 2019 walked into a Los Angeles bank and insisted that someone had been using his credit card to accumulate large amounts of debt. He wanted to close the bank accounts, but he was unable to answer the security questions, so the bank contacted the police. The police arrested Woods after Kierans convinced them the victim was trying to defraud him. And all the while, the victim insisted that he was, in fact, the right Mr. Woods. But prosecutors didn't believe him, and he was deemed incompetent to stand trial at one point, according to the court records. Now, the victim ended up pleading no contest to charges in exchange for being released for the time that he was in custody. Overall, he spent 14 months in jail and nearly 5 months in a mental facility where he was forced to take psychotropic drugs. My God, this sounds like something out of a horror movie. But the tide began to turn for Mr. Kieran when Woods called the hospital where the fraudster worked to complain. The hospital, in turn, reported the complaint to the University of Iowa Police Department, and a guy by the name of Detective Ian Mallory began to unfurl the 3-decade scheme. Now, Kierans told Mallory, the detective, that his victim was crazy and belonged in jail. Undeterred, Mallory continued his investigation and obtained the victim's DNA, which proved he was indeed who he said he was, and that it was Kieran who was the criminal. Ultimately, Kierans admitted to the crime. In addition to the prison sentence, he has to repay $16,000 in fines and restitution. Unbelievable, ladies and gentlemen. You can't make that stuff up. All right, we didn't really talk about it much on CrimeTalk, but there was this trial for this Dominique Pelicot guy that he did horrible things to his wife, drugged her, had other men come over and do stuff. Anyway, he got convicted a couple of weeks ago, but guess what? He's in more trouble. So Dominique Pelicot, the convicted rapist who basically shocked France by drugging his then wife so other men could rape her, was questioned about another case last week of and murder where he just happens to be a suspect. Now, Pelicot is only serving a 20-year prison sentence after he was found guilty in December for the horrific sexual abuse of his now ex-wife, Giselle Pelicot. His lawyers said that he now faces renewed questioning by an investigating magistrate who specializes in cold cases. Now, the rape and a murder allegedly took place back in the 1990s. One involves Sophia Narmet, a property agent who was killed in Paris in 1991. His lawyer, Beatrice Savaro, said that Dominique Pelicot denies his involvement in the killing. The other is the attempted armed rape of another property agent in Paris suburb of another city in 1999. In that case, Pelicot acknowledged that he met the woman and tried to undress her, but denies attempting to rape her. Now, Dominique Pelicot has been under formal investigation for both of these crimes since October of 2022. A legal status, meaning that investigators believe there is accumulation of serious evidence against him. Now, victims' lawyers say cases tied to multiple. Lawyer Florence Rayault, who represents Narmet's family and the woman subjected to the rape attempted, said the array of similarities between the 1991 and the 1999 cases suggests the perpetrator might be the same. One has to remain cautious. Perhaps someone else committed the crime on Sophie Narmet. But there are such similarities in the mode of operation, in the way the victims were approached, and the victims are so identical to that one can legitimately ask many questions, the attorney noted. Now, the two cases were grouped together in one investigation in September of 2022 that was taken over by the Specialized Unit for Cold Cases and Serial Crimes. It works out of Paris and is working on the case. Now, Pelicot's lawyer says the cases are different. Speaking on her way into Pelicot's hearing, the attorney with the investigation magistrate at the cold case unit, a woman by the name of Zavaro, said her client plans to cooperate. She noted that he had previously been questioned in 2023 and had acknowledged having been in contact with the property agent in 1999, but not with Miss Narmet. He has always said that he never met Sophie Narmet, adding that Dominique Pelicot has acknowledged to investigators that he met the other property agent. Pelicot's lawyer said police found traces of his DNA at the scene of their meeting. He apparently acknowledged having an altercation with her and having tried to undress her, but with the intentions were much different than. Anyway, Pelicot's lawyers sought to separate the current investigation from the abuse he inflicted on his then wife. The attorney said, "Let's remember, he benefits from the presumption of innocence. Let's not make him into a guilty party ahead of time." She described his conditions in solitary confinement and said he has not been allowed visitors since 2020. It's an isolation measure that was imposed on him and that he lives with every day. He is not complaining. He knows it was imposed on him based upon the nature of the facts. Well, these cases all predate the drugging of his former wife. Now, Mr. Pelicot, who's now 72, could spend the rest of his life behind bars. He won't be eligible to request early release until he served at least 2/3 of his 20-year sentence, which was the maximum possible for the rapes and other crimes he was convicted of. Now, the murder cases occurred more than 10 years before the drugging and rape cases of Giselle Pelicot, for which Pelicot and 50 other men were convicted, a nearly decade-long stretch of sexual abuse going back 2011. He would drug her unconscious by lacing her food and drink with drugs, then invited other men he met online to come over and rape his wife. Now, Giselle Pelicot became a hero in France and beyond for courageously demanding that the men's trial be held in open court. The evidence included some very stomach-churning videos of the abuse that Dominique Pelicot filmed in the couple's retirement home in the small province town of Mazan and elsewhere. Police subsequently found more than 20,000 photos and videos in all, stored on computer drives and cataloged in folders marked "Abused," "Horrendous," "Night Alone," and other titles. Horrible case. We don't often cover cases overseas, but that one just probably should have spent more time on it. But I love how his wife was like, "Oh no, we're going to have a public trial. And all of these men and the world is going to see what these people did to me," while she was completely knocked out and unwilling or unable to resist in any way whatsoever. Next, this guy's boots got him identified and arrested. A Boca Raton man's footwear may have been his downfall after police say he wore his same cowboy boots to the burglary. A pawn shop, according to police records. On January 22nd, Boca Raton Police Department say that they began investigating a construction burglary that occurred on January 9th. in Boca Raton. A project manager told police that an unknown man, later identified as a 61-year-old Rick Stornat, stole 6 boxes of Kohler shower equipment totaling about $3,000 from a warehouse about 8 p.m. by prying open a plywood wall to gain entrance into the building. Police say the suspect was captured on security footage and identified as a white man, wearing a dark zip-up hoodie, jeans, gloves, and a unique pair of cowboy boots with buckles. An initial investigation of pawn transactions involving Kohler products led the police to a company called American Pawn. Guess what? There was video footage from the pawn shop, and it was shown to the police, which reportedly revealed that the man in the cowboy boots, who resembles the burglar, completed the transaction in his cowboy boots. When analyzing the boxes, police noted that the exterior had MB marked on it, signaling master bathroom, which the project manager told the police that he wrote for the construction team to know which area to put the items in when they were doing the construction. Anyway, on Tuesday, police said that Stornat was arrested for an unrelated traffic incident on his moped, which the pawn shop security footage showed him leaving in and wearing the same brown cowboy-style boots with buckles. Detectives say they interviewed Stornat, and he confirmed that he went to the pawn shop but grew quiet when the video footage was shown of the alleged burglary. Stornat was subsequently booked on all counts and charged with dealing in stolen property, larceny, burglary, and false identification, providing it to the pawn shop. Can't make this stuff up, ladies and gentlemen. Next, another reason to avoid dating apps. 2 men are accused of murder, and they'll be back in a Cook County courtroom later this week. Police say 21-year-old Guidaroon Morales and 29-year-old Jefferson Ubila Delgado are accused of killing a 63-year-old man by the name of George Levin at his home on January 23rd. Cameras weren't allowed into the courtroom when they made their initial appearance, but nevertheless, prosecutors argued that what happened to Levin was apparently horrifying. After receiving a call from relatives, the Chicago police said they found Levin dead inside his basement, tied in duct tape and electrical cord. He was partially naked and had a sock stuffed into his mouth. Prosecutors pointed to evidence from surveillance cameras showing the 2 suspects arriving and leaving Levin's home the night that he died. Police also found duct tape near one of the suspects' vehicles. Police said shortly after the suspects allegedly beat Levin, they robbed him and his cell phone and wallet because they were missing from his person. Prosecutors said surveillance video showed the suspects visiting a nearby vape shop and gas station where they tried to use the dead man's debit card. They ultimately spent over $4,000 on Amazon transactions. By tracking items like Levin's cell phone and an electronic monitor device being worn on one of the suspects, that's an ankle monitor, they were able to find 2 suspects and arrest them both. The suspects' attorneys argued in court that despite the videos, there was no evidence to prove exactly what happened inside the basement. They also argued that the 2 men ended up with Levin's phone as a part of a payment for sex. Okay, and then they tied him up and left him. Anyway, the victim and Morales are said to have been previously communicating through a dating app. The judge denied pretrial release for both, and they'll be back in court later again this week. Next on the docket, this day in legal history. On February 3rd, 1870, ratification of the 15th Amendment. That's right, on February 3rd, 1870, the 15th Amendment to the United States Constitution was ratified, granting Black men the right to vote by stating that the right to vote shall not be denied based upon race, color, or previous condition of servitude. Obviously, it was a pivotal moment in American history, aiming to ensure that Black men could participate in the electoral process, although various discriminatory practices would later emerge to try to undermine the effectiveness of the amendment. Then on February 3rd, 1913, we have the ratification of the 16th Amendment. That's right. The 16th Amendment to the United States Constitution was ratified, granting Congress the authority to impose a federal income tax without apportioning it among the states or basing it on the U.S. Census. What's legally known as the progressive income tax, that, the more you make, instead of everybody kind of paying the same, the more you make, the more you pay. Yeah, that's right. And we didn't have a federal income tax until that time, ladies and gentlemen. how did the federal government do their jobs of national defense, trade, interstate commerce, tariffs? We still have tariffs, and we still have taxes. We'll see if it all goes away. Anyway, obviously, this led to the modern-day income tax system and expanded the government's fiscal capabilities. And then on this date in 1941, the United States Supreme Court upholds the federal wage and hour law. That's right. The United States Supreme Court upheld the constitutionality of the Fair Labor Standards Acts, which establishes minimum wage and maximum hour regulations. So there you go, ladies and gentlemen. And then finally, our dumb criminal of the day. A 7-Eleven customer used a banana to assault a store clerk, according to a police report. Catavella Turner got into a verbal altercation with a 30-year-old female worker, and the woman exchanged derogatory comments towards each other. It happens. At one point, Turner became irate, picked up a banana from the cashier counter, and threw the banana at the victim's face. The fruit struck the employee on the cheekbone, leaving a minor abrasion. The banana was not seized as evidence, just in case you were wondering. Anyway, Miss Turner was arrested for battery and booked into the county jail on a misdemeanor. Police records do say that Miss Turner's employer has Baby Dolls, a gentleman's club located about 4 miles from the 7-Eleven. Turner is being held without bond for violating, guess what? Probation in connection with a theft case that she had. Anyway, that felony case, Turner has previously been cited for failing for pretrial intervention, as well as not performing her 75 hours of community public service. She was also arrested for resisting and giving cops a false name when they responded to a trespass call at Baby Dolls. She was free on a $1,000 bond on that particular case. I don't know what to say, ladies and gentlemen. I don't know what to say. Anyway, Miss Turner, you are a dumb criminal of the day. Congratulations. You made it. Tell all the ladies down at Baby Dolls about that little award. All right, that's all we have for today, ladies and gentlemen. Have a wonderful day. We'll see you next time on Crime Talk.